Mans vārds ir Edijs Poga, esmu Zernāts advokāts un biedrības Latvijas tiesību institūts direktors. Biedrība Latvijas tiesību institūts ir neatkarīga, nepolitiska, nevalstiska bezpēļņas apvienība, kurā apvienojušās personas ar kopīgām interesēm par Latvijas tiesībām un to attīstību. Institūts vienmēr un visur darbojas neatkarīgi un stāv ārpus politisko partiju vēstās politikas. Institūta misija ir veicināt Latvijas Republikas kā demokrātiskas taisnības un tiesību valsts tālāk atjaunošanu, nostiprināšanu un attīstību. Institūta vārdā man ir tas gods jūs sveikt institūta ārvalstu akadēmiķu vieslekciju programmas atklāšanas reizē. Priecājos jūs redzēt tik kuplā skaitā un pateicos jums par interesi un atsaucību. Šādu vieslekciju programmu esam iecerējuši, jo mēs esam maza tiesību sistēma ar ļoti ierobežotiem resursiem. Tādēļ pēc iespējas mums jācenšas lūkoties lielo Eiropas tiesību sistēmu virzienā ikreiz, kad mēs domājam par mūsu tiesību sistēmas tālāku attīstību. Eiropas tiesību sistēmu vadošo akadēmiķu vieslekciju cikls Rīgā mums lieta noderēs šajā sakarā. Konkurences tiesības savukārt ir viena no Latvijas tiesību institūta sevišķām fokus jomām, tādēļ arī vieslekciju programmu mēs atklājam tieši ar Londonas Karaliskās koledžas emeritētā profesora Richarda Whiša vieslekciju Rīgā. Es domāju, ka profesoram Whišam nav nepieciešama sevišķi priekšā stādīšana, jo esmu pārliecināts, ka lielākā daļa no mums zina, kas ir profesors Whišs, un tādēļ es izlaidīšu garu ievadu par profesoru akadēmisko karjeru un sasniegumiem un došu vārdu profesoram pašam. Vēl tikai piebildīšu, ka šodienas vieslekcija ir saturiski sadalīta 3 daļās, un tā ilgs aptuveni 2 stundas bez pārtraukuma. Pēc katras no daļām jums būs iespēja uzdot profesoram jautājumus par konkrētās sadaļas tēmu, un lekcijas beigās mums būs neliela jautājuma atbilžu sesija, kas skars ne tikai šodien apskatītos jautājumus, bet arī tiks atbildēt jautājumi, kas ir konkurences tiesība, bet kas neskar tieši šodienas tematu. Latvijas tiesību institūta vārdā es vēlos pateikties konkurences padomei, augstākajai tiesai, Latvijas administratīvo tiesnešu biedrībai, juristu vārdam un mazai ģildei par atbalstu šī pasākuma sarīkošanā. Un tātad, dāmas un kungi, man tas gods stādīt jūs priekšā profesoru Richardu Whišu ar vieslekciju tirgus varas nozīme Eiropas Savienības konkurences tiesību piemērošanā un kā to izmērīt. Lūdzu sagaidīt profesoru ar aplausiem. Paldies!
Well, good morning, ladies and gentlemen. It's an enormous pleasure to be here. Thank you very much for the introduction. Of course, I've no idea what you said, but I certainly heard my name. It is a pleasure to be here. I think I was last in Riga in 2002, which feels like an entire generation ago, but it's wonderful to be here. Beautiful city, beautiful building. The Craftsman's Guild, I gather, which makes me think an association of undertakings. Think of the history of this building and how competition law would apply to the events of 100, 200, 300 years ago. Anyway, I've been asked to talk about the importance of market power in the application of EU competition law, how to measure it. It does occur to me, speaking to an audience of competition lawyers and officials from the authority, that some of what I'm about to say may be rather basic, and most of you will understand the mechanics of market definition and the assessment of market power. So I apologize if some of this does seem rather basic, but I hope at the very least that I can encourage you to ask questions. Maybe we can have a debate in due course as I proceed with the lecture. Just to explain the structure of what is to come, I will start with some introductory comments about competition law and policy and the way in which the system has grown over the years. I'll then discuss the meaning of market power. And as I say, I know that you're familiar with this concept, but sometimes it's quite good to go back to the beginning and remind ourselves of basic underlying concepts. I'll talk a little bit about the assessment of market power, and what I want to stress there in particular is that market definition does not provide us with an answer. It's a tool towards determining whether someone has market power, but we, especially as lawyers, we should not overly concentrate on market definition. Then, part of my talk, I will discuss this rather controversial subject of what is a restriction of competition by object. We all know that Article 101 talks about agreements that have as their object or effect the restriction of competition. It's a controversial subject, it's quite a difficult subject, and it's quite interesting to address the question, does one need to look at market power when analysing a restriction of competition by object? I think that's quite an interesting topic, and I've got some things to say about that. And then I will reach a conclusion. What I thought I would do is, we've actually got 2 hours allotted for my speech, and it seems to me that for you to listen to one person talking for 2 hours is a feat of endurance that you shouldn't have to go through. So I thought what I might do is, at the end of the section on market power, I might then stop and ask whether people have got questions and comments, and then in due course move on to the question of restriction of competition by object. That will break up the session to some extent. The other thing to say is, I don't know whether you said this in the introduction, but these slides will be made available on the website of the Latvian Law Institute. So if people want to follow up after this, they will be available publicly. Okay, so that's what I'm proposing to cover. So, introductory comments. It's rather fascinating to think that today in 2014 there are something like 130 systems of competition law in the world. When I started my career in competition law, I don't want to say what year that was, but it was quite a long time ago. But when I started studying competition law, there were about 5 systems of competition law in the world that one needed to take seriously. Obviously, the United States, Canada as well, the EU, Germany. The United Kingdom had something, but it didn't really amount to very much. So that's how competition law looked in those days. Now here we are in 2014, roughly speaking, 130 countries in the world have systems of competition law. Insofar as competition law is there to promote consumer welfare, competition law is an instrument to protect the interests of consumers. It is quite interesting to contemplate that in the last couple of years, India and China have adopted competition law. Those systems are now very much up and running, which is another way of saying that something like 2.5 to 3 billion additional citizens of the world have been brought within the protection of competition law. It is a pretty extraordinary thing to think about. And also, if you look around the world, I do find it fascinating that every type of economy now has a system of competition law. So this is not just a game for the rich, developed Western world. Any kind of economy, it could be agricultural, it can be trading, it can be small, it can be large, developing, developed. We find competition laws absolutely everywhere in the world. So you can go to Panama, Papua New Guinea or Poland and you will find competition law. And what I find particularly interesting is the incredible degree of convergence that now one sees around the world of competition law. Many years ago, when would this have been? In the early 1990s, I was asked to do some research by the OECD on the possibility of convergence of competition law. And in those days, the feeling was that states and economic conditions and political conditions and cultural values were so different around the world that it was really more or less impossible to ever hope for convergence of substantive standards of competition law. This was a kind of a dream, but an unattainable dream. It might be possible to harmonize procedure to a certain extent, but it would never be possible to harmonize standards. So that was a perception 20 years ago. But if you look at the position today in 2014, with 130 systems of competition law around the world, it is quite remarkable to my mind just how similar they all are. Of course, there are some differences, but they're sort of distances at the fringe. But in terms of the core of what these laws are about, they really are very similar indeed. And just to give a couple of examples, within the last 10 years, Singapore has adopted a competition law and Malaysia has adopted a competition law. And I quite regularly go to those two countries and talk with the authorities and the judges and the practitioners. And both the Malaysian and the Singaporean acts are basically copies of the United Kingdom Competition Act. Now that's understandable in a sense because Singapore and Malaysia share a common law background, and the lawyers of Singapore and Malaysia very often have had their legal education in the United Kingdom or in Malaysian and Singaporean law schools which are based on the common law system of the United Kingdom. So it's somewhat understandable that when they adopt legislation in a new area such as competition law, they look to the United Kingdom, they find our Competition Act of 1998, it sort of makes sense, it's fairly coherent, and so they cut and paste from UK law into Singaporean and Malaysian law, and they're comfortable with that. And then I go to Singapore or Kuala Lumpur to talk about this UK legislation, and have to explain to them, but you do realise that the UK legislation is Articles 101 and 102 of the treaty. And furthermore, this is an interesting point, and I don't think you have this in Latvian law, but our Competition Act in the United Kingdom has a section, Section 60, that says when the competition authorities and courts in the United Kingdom are applying the Domestic Competition Act, that they must do so consistently with the jurisprudence of the European Court of Justice in Luxembourg. So insofar as what we call our Chapter 1 prohibition prohibits agreements, decisions and concerted practices, etc., if you had a domestic case in the United Kingdom and a question arose as to the meaning of concerted practice, the courts in England must interpret concerted practice consistent with the jurisprudence of the Court of Justice in Luxembourg. And so what that means is, in effect, that a judgment like the Dyestuffs judgment of 1969, before the United Kingdom was in the European Union, but the Dyestuffs judgment of 1969 becomes part of the domestic law of the United Kingdom. And then Singapore and Malaysia have the same legislation as the United Kingdom. So the natural thing for them will be also to adopt the jurisprudence of Luxembourg in interpreting Malaysian competition law. It's quite a remarkable idea, isn't it? So what was decided in the Treaty of Rome in 1957 in effect becomes the competition law of Singapore and Malaysia and many, many other countries around the world that have adopted the language of Articles 101 and 102. I do find this a rather fascinating phenomenon, and so this is my point about convergence, of course. And one thing that occurs to me to say, I don't know whether people have thought about this, but there's all that legislation and jurisprudence in the United States based on the Sherman Act and the Federal Trade Commission Act. But in the United States, you don't get a continual flow of decisions that get published containing all the details and the legal analysis. And because you don't get published decisions, you don't get appeals to the American courts. Because an awful lot of what happens in the United States is consent decrees and agreements between the parties. You know, yes, we were in the cartel, so you don't get a published decision. Similarly, when a merger gets cleared in the United States, all we know is that the merger was cleared. But you don't have a decision that might be 20, 50, 150 pages long explaining why UPS and TNT was prohibited or why Ryanair and Aer Lingus was prohibited. Whereas in the European Union, because we have the commitment to transparency that we have, every time the Commission adopts a decision, it is published. Then very often there's an appeal to the General Court and to the Court of Justice, and then you get a judgment which is 50, 100, 150 pages long. And all of this goes into the public domain. It's on DG Comp's website. It's on the Court of Justice's website. It means that there's a wealth of published material explaining how 101, 102, and the merger regulation are applied in practice to real live cases with facts, context, and so on and so forth. So very little about case law published in the United States, a massive material published about cases in the EU, and it has a very fascinating effect because it means if you go to India, for example, I go there quite regularly and talk to practitioners and the authorities there, you find that the decisions that are adopted there are heavily reliant on EU precedent because the precedent is all there, the decisions are all there. And, you know, in a sense, a merger is a merger is a merger. And so if you've got published decisions explaining how the European Commission reached its decision in such and such a merger case, of course the Competition Commission of India is going to look at the published decision. They might reach a different conclusion, but they are going to be influenced by what is in the public domain. You don't have that material published in the United States. And so it seems to me that in 2014, we in Europe have a greater influence in the broader world than the United States does simply because of the nature of our decision-making processes. It's a rather fascinating thing to contemplate. Anyway, this does lead to a remarkable degree of convergence, and I'm going to come on to what happens in terms of cartels and abuse in due course, but there is a great deal of convergence around the world, much more than I think was ever thought to be possible 20 or so years ago. And of course, a really important part of this whole thing is the emergence of the European Competition Network and the International Competition Network. I think what's been achieved here is absolutely remarkable. You know, the idea that the European Commission and 28 national competition authorities regularly meet, discuss issues, have subgroups, have an intranet, etc., etc. I think it is a truly remarkable achievement. And because those competition authorities are continually talking to one another, of course, it leads to a kind of convergence. Let's call it a soft convergence rather than a hard convergence. But I think what happens is that when competition authorities meet one another, they find that they're speaking a common language. And it's a kind of a mixed language of law and economics, where they, broadly speaking, understand what they're trying to achieve. And what I find around the world is that very often the differences of opinion, the disagreements, take place between a national competition authority and its own government, because often the government wants to achieve something which might be different from what the competition authority wants to achieve. And so you actually find that for some competition authorities, their friends in the world are the other competition authorities. And it might be that by discussing things amongst themselves, it emboldens the national authority to assert its independence opposite the government when the government wants the authority to do something other than what the authority would naturally do. So this whole business, I think, is an absolutely fascinating one, and we've come a remarkable distance in a relatively short period of time. Now, if we then move nearer to the subject matter of the lecture, competition law, in the sense of the actual legal rules that are administered by competition authorities, are, of course, concerned with three basic things: agreements that restrict competition, mergers, and abuse of dominance. You all know that. Just to note in passing, there are some competition regimes in the world that address only agreements and abuse of dominance. Some competition regimes do not contain provisions on mergers, which seems to me to be really a rather foolish position, to be perfectly honest, because if you don't have control over mergers, but you do have control over cartels, it seems to me that you have a legal system that incentivizes would-be cartelists to merge, because if they merge, they'll be in the same position as the cartel, but they will be outside the scrutiny of competition law. But there are systems in the world that don't control mergers. Malaysia is an example of that, and Hong Kong has recently adopted competition law, but it does not have provision on mergers except in the telecoms and broadcasting sectors. But those are, broadly speaking, the three pillars of competition law: control of agreements and abuse, and often, but not always, mergers. So I always refer to these as the three pillars of competition law. Of course, competition authorities do something else as well, which is to act as advocates for competition. Now, that's not a legal requirement necessarily, but nevertheless it is something that competition authorities can do. And to be a competition advocate involves looking at state behavior, including legislation, planning laws, licensing requirements, etc., because, let's face it, nobody distorts competition better than the state. The state has the ultimate amount of market power. It can do what it likes, and politicians have lots of reasons for doing the things that they do, and many restrictions of competition are state-created. So that's when I think it is highly desirable to have a competition authority, and it should be a competition authority which is genuinely independent of the state, that is given the opportunity to look at legislation or to look at proposals, and then independently to analyse and assess whether these proposals are restrictive of competition, or if they are restrictive of competition, could they be less restrictive and still achieve some other public interest outcome. And I think it's been fascinating in the last few years to watch just how much this role of competition authorities as competition advocates has grown. It's become an entire subject in its own right, and the International Competition Network has an advocacy working group which I think has been responsible for superb recommendations in this field in recent years. I mean, this is where you get convergence by an international institution bringing people together and trying to develop best practices. So if people aren't aware of that work on advocacy of the ICN, I would strongly encourage you to have a look at the website, where you'll find lots of very interesting material. Anyway, so those are our three pillars. And this is going back to very basic ideas, but there is a common thread that brings the three pillars together. We have rules on cartels, we have rules on mergers, we have rules on abuse of dominance, But actually, when you stop and think about it, they're all concerned with the same underlying issue, and that is market power. Now, it's an interesting thing that most legislation does not refer to market power. Okay, we have a rule on abuse of dominance, and dominance manifestly is something to do with market power. But the laws on cartels don't refer to market power. Merger provisions don't normally talk about market power. They might talk about substantially lessening competition or significantly impairing effective competition, but the expression market power is not normally found in the legislation. So really, it's been left to authorities, to courts, to academics over many, many years to try to work out what is this subject all about? Is there some single conceptual idea that binds it all together? And of course, actually, we can now see it really is all about market power. So let's just unpack that. Let's think of a cartel. Why don't we like a cartel? Because in the theory of perfect competition, you have an infinite number of producers of widgets. You all know what the widget is, the mythical product of any competition law exam question. You have an infinite number of producers of widgets, and in perfect competition, none of them has any individual market power. Their output decisions cannot have any influence on market price. And so this is the perfectly competitive market where marginal revenue intersects with marginal cost, etc., and we live in the best of all possible worlds. What is a cartel? A cartel is a situation where those firms who are meant to be making their own individual decisions actually decide to get together and to act collectively. So what are they doing? They are giving to themselves market power, which individually they lack. So sometimes I think people don't think of cartels in market power terms, but actually it is about market power. It is about operating in a cooperative manner that enables you to raise price. I'll come on to the definition of market power in a moment, but that is actually what anti-cartel law is all about. What about our abuse provisions? Our abuse law is normally framed as follows. It is prohibited to abuse a dominant position. And then it took the Court of Justice in Luxembourg 30, 35, 40 years to work out what was meant by a dominant position. It's an interesting idea that these words dominant position were used. Where did those words come from? My understanding is they actually came from a German anti-cartel law of 1923 when Germany passed a law prohibiting cartels, and they just added another section that said, and you mustn't abuse a dominant position. But that provision was never used. It was there on the statute book, but it existed. And then when it came to time to write the Treaty of Paris and then the Treaty of Rome, there were these words in the German Anti-Cartel Act of 1923, and somebody said, oh, let's use that. So the words get copied across from a 23 Act in Germany to the Treaty of Paris and the Treaty of Rome. You mustn't abuse a dominant position. And then, of course, it was left to the Court of Justice to work out, well, what is a dominant position? And after about 40 years or so, especially when the economists had come increasingly into competition law and policy, we came to understand that really what a dominant position means is significant market power. And you'll know that now in things like the electronic communications framework system, EU law now says that dominance equals significant market power, and that significant market power equals dominance. I can remember a rather bizarre period in the 1990s when there were regulatory systems that contained the expression significant market power. Article 102 talks about the abuse of dominant position. And people used to ask me, Richard, can you tell me, is significant market power more market power than dominance or less market power than dominance? And I know that different people gave different answers to that question. And then there was another expression, substantial market power. So was substantial more than significant or less than significant? And furthermore, was substantial and significant different from dominance? I mean, this was a very, very strange position to get oneself into. But what we say now in 2014, and the Commission says this in the Article 102 Enforcement Priorities Guidance, that significant market power is dominance, and dominance is significant market power. So I think that's a wholly beneficial development. But of course, it makes my point that that part, that pillar, is based on market power. And then what about mergers? Different merger laws are expressed in different ways. Some merger laws says a merger will be prohibited if it would create or strengthen a dominant position. Some merger laws say a merger will be prohibited if it substantially lessens competition. That's the expression that we use in the Anglo-Saxon world, the SLC test. So you'll find that in Canada, Australia, the United States, the United Kingdom. Other systems of law, the EU merger regulation says that a merger will be prohibited if it would significantly impede effective competition. So you have different linguistic tests for merger control, but actually they all add up to the same thing, which is that a merger will be prohibited if it's going to create or strengthen market power. And you look around the world, this is my point of convergence again, you read the guidelines on merger control in the United Kingdom, the United States, wherever it might be, in the end, it is about market power. Will the post-merger entity be able to exercise market power? So it is the central concept. There's no avoiding it. You cannot be a competition lawyer without being confident in your ability to understand the concept of market power and, in most cases, hopefully reach a conclusion on market power for yourselves. In difficult cases, of course, you will want to bring in the economics consultancies because in practice this can be a very difficult matter. But competition lawyers have to feel comfortable with the process of analysing markets and determining market power. So therefore we've got to have a definition of what is meant by market power, and it means the ability to profitably increase prices above the competitive level over a significant period of time. That is basically what we're talking about. So in an abuse of dominance case, we're trying to work out whether DOMCO is dominant. We ask ourselves, is DOMCO in a position to raise its prices and to keep the prices at a higher level over a period of time and still go on making profits? Because, of course, if it can do that, it means it's not subject to effective competitive constraint. And if it's not subject to effective competitive constraint, obviously it is in a position to exploit its customers over a period of time. For a long time, that expression, probably to you nowadays as practitioners of the subject, it's obvious to you, but even 10 years ago, it wasn't common for competition lawyers and policymakers to use this terminology. But I think now, today in 2014, we are all comfortable that that is actually what we are talking about. And even the European Commission has only used this formula in relatively recent years. And the best statement of this, I think, is in the European Commission's guidance on enforcement priorities under Article 102. I mean, probably the most difficult bit of all of competition law, where the Commission discusses what is meant by dominance, and they say dominance means significant market power, and significant market power means that full first bullet point. So when you want to get back to the basics of the subject, that is the phraseology always to bear in mind. But the second bullet point is important. In some markets, the classical DOMCO, how does it exploit its consumers? It does so by raising prices. And so the definition of market power is the ability to profitably increase prices. But DOMCOs can exploit their market power in other ways. Sometimes they simply increase their price. In other situations, they don't actually bother with the price. They just decide what their output will be. And of course, by restricting output, they can lead to an increase in price. And so it's quite interesting to hear, when we hear about the OPEC oil cartel, the headline on the news is never that OPEC has raised the price of oil. The news always tells us that OPEC has decided to restrict the output of the various oil-producing nations to X million barrels a day. So OPEC is absolutely about an output restriction cartel rather than let's sit down and work out the price. I mean, the two things are opposite sides of the same coin. And then there are other markets which are typified by high innovation. You can think of this as, IT markets, mobile telephony, and so on and so forth. In some markets, the motor of competition is not price or output. It's actually developing new, better, cleverer, smarter products. Well, manifestly, a lot of IT markets are highly innovative, and people all the time are looking for new ways of doing things. We heard the other day of Apple buying Beats because it wants to get hold of its streamlining business for music. This is innovation on the part of Apple. But if one had market power, then one of the ways of manifesting the market power would be to say, we are so free from competitive constraint that we don't really need to innovate any longer because nobody is there about to enter the market and challenge us. And then in other markets, you might just restrict choice. In other markets, you just might not bother with the quality of your service because you're in such a powerful position that even if you degrade standards of service, you're not going to be disciplined by other people in the marketplace. So the reason I say all of that is, and the Commission specifically says this in the enforcement priorities guidance, that when we define market power as the ability to profitably increase price, you really need an asterisk alongside the word price. And then the footnote says price includes output, innovation, choice, quality, etc. So the word price, it's a sort of a portmanteau word that includes lots of other manifestations of competition. So there we are. Now, next point to make, and I think this is an important and an interesting one when it comes to, as it were, the interface between law and economics. I don't want to overdo the law-economics tension, but there has always been a tension between law and economics, or more specifically, between lawyers and economists, because lawyers sometimes get frustrated with economists who aren't interested in legal rules. They just simply want to know the effects of behavior in the market. And if there are no effects, well, why would anyone be concerned? Whereas Lawyers get frustrated by that. Economists get frustrated by the fact that we as lawyers have legal rules which can sometimes be applied in a rather formalistic way. And of course, if you have formalistic rules, you are inevitably going to get errors, because there will be certain circumstances in which behavior that is harmless gets condemned, and you'll have other situations in which behavior which is bad actually does not go punished. So you enter this whole world of false positives and false negatives. And there have been situations, and there are still situations, where the lawyers and the economists are at loggerheads with one another. As my career has developed, watching this law economics tension, I think it's terrific how much the situation has improved. And I think it's one of the single best things that has happened in competition policy over the years. And it works both ways, that lawyers increasingly do understand the economics, or at least, if not the economics, the economic principles. I'm not saying that lawyers can do the mathematics, the equations, the logarithms, the algebra. Lawyers tend not to feel comfortable with that, but they can understand the principles that are driving the subject. And furthermore, economists, I think, have increasingly come to understand that the application of competition law in practice does require a legal process. One has to respect the legal process, and it's something I'm going to talk about in due course. Part of the legal process can be that one has presumptions, because the presumptions determine who has to prove what. And of course, as you know, there is a presumption of dominance at 50%. But as long as it's just a presumption, as long as DOMCO can still produce evidence to show that at 70% it is not dominant, this doesn't matter. It's just a presumption. It's determining who has to prove what. So I think that law and economics now work together much, much better than they used to do. But just to make a point here about law and economics is that market power is a relative concept. So if you've got the laboratory model of perfect competition here and monopoly over here, they are textbook concepts. This is a perfectly competitive market where nobody has any market power whatsoever, so nobody can influence price. This is pure monopoly over here, where I just determine my output, and this leads to a deadweight loss, and so on and so forth. These are theoretical concepts, absolute market power and no market power whatsoever. Of course, the real world isn't like that, because you've got a continuum that goes from perfect competition to monopoly, and you've got one firm here that has a bit of market power, and you've got another firm here that has rather more market power, and then you've got somebody over here that has significant market power. It's all relative. And I can absolutely see how an economist would say, well, you've just do have to look at the facts of every case and use your judgment to decide whether in this case there's so much market power that there's a problem. But law doesn't always express itself in that way, in particular because of the rule on abuse of dominance. Because Article 102 says you must not abuse a dominant position. And of course the point is that if this is the continuum with a bit of market power, a lot of market power and significant market power, that is all relative. But what Article 102 says is that at some point along this continuum, you become dominant. And of course, dominance is a binary concept. You are either dominant or you are not dominant. And I think this is what makes the law of abuse so controversial, because it means that if an authority or a court gets dominance wrong, it might end up wrongly accusing a firm that is not dominant of abusive behavior, and so it gets fined and sued for damages and so on and so forth. Whereas in actual fact, its price cuts may have been pro-competitive. Equally, however, you might decide that somebody is not dominant, but in actual fact it was, in which case its exclusionary behavior, which is keeping as efficient competitors out of the market, is permitted rather than being prohibited. So there is something rather intriguing in this whole world of abuse of dominance, that you use a binary concept. And I think in law it has to be binary, because you say the dominant firm has these responsibilities and the non-dominant firm doesn't have those responsibilities. But it does mean it's incredibly important to get the assessment of dominance correct. Because if you get it incorrect, you're going to get both false positives and false negatives, and both false positives and false negatives are bad for consumer welfare. So I think this is one of the reasons that the abuse of dominance bit of law is as controversial as it is. So there we are. That's some thoughts on market power and a definition. But of course the real question is, how do we assess this in practice? Now, some of what I'm about to say will be very obvious, and I'm not going to bother going through the snip test, etc., because that would be to insult your intelligence. But what we do know as a matter of law is that if an authority or a court intends to reach the conclusion that somebody has a dominant position, we know from Continental Can and the Commission in 1973 that that authority must define the relevant market. So this came up in Continental Can, an Article 102 case, where Continental Can acquired its only main competitor. And at the time, 1973, there was no merger regulation. And so the Commission looked at somebody who's apparently very, very dominant. It's really only got one effective competitor, and it acquires it. And the Commission boldly, imaginatively says that must be an abuse of a dominant position. To acquire your only effective competitor, that must be an abuse. And the case goes up to the Court of Justice, and Continental Can argue that mergers cannot be abusive. If you look at Article 102, the examples of abuse are things like charging unfair prices, exploiting your consumers. So the Continental Can argument is that mergers aren't the kind of thing that are captured by Article 102. 102 is concerned with the monopolist that is gouging its customers. And the Court of Justice says, no, we don't think that's right. I mean, of course, exploiting customers can be an abuse, but acquiring your only effective competitor in itself can be an abuse, because it will lead to a situation where you can exploit your customer. So as a matter of principle, mergers can be captured by Article 102 if they would strengthen a dominant position, thereby significantly impeding effective competition. And go back and read the merger regulation as it is today in 2014. What is the test for prohibiting a merger? Will it significantly impede effective competition? It's quite an interesting thought. That expression, SIEC, was used by the Court of Justice in 1973, and today, post-2004, it is the substantive test of merger control. But the Commission lost in Continental Can. So the court says, yes, mergers can be abusive, but this decision has to be annulled because you, the Commission, failed to define the relevant market in which you allege that Continental Can is dominant. And so right at the beginning of time, so to speak, this is the first major judgment on Article 102, the Court of Justice says, as a matter of law, you must define the relevant market. Then, of course, a few years later, 16 years later, the merger regulation was adopted. And what did the merger regulation say? A merger would be prohibited if it would create or strengthen a dominant position. That was the language used in 1989. And so the Commission and the Court said, well, if you have to define the relevant market for the purposes of dominance under Article 102, and given that the merger regulation talks about creating or strengthening a dominant position, well, obviously, you have to define the relevant market for the purposes of merger control as well. And so we now know that both under 102 and the merger reg, you have to define the relevant market. Then Article 101 talks about agreements that have as their object or effect the restriction of competition. Well, if you're saying that an agreement has an effect on competition, that can't mean an effect on competition in the abstract. It must mean an effect on competition in a relevant market. And so just as market power is common to all three pillars, market definition also becomes common to all three pillars, subject to the object restriction bit, which I will deal with later on. Now, the reason I'm stressing all that is that this was the court saying to the Commission, you must define the relevant market. And so then all of us had to learn how to define the relevant market, and the next few slides talk about that, but I won't go into detail on it. And so in a sense, this is the court telling the Commission, and then us as lawyers, that we've got to learn how to define relevant markets. And in a way, it's sort of saying you've got to think in terms of economics, because a market is an economic concept. And so you've got to define the relevant market. And I remember, in the 80s and 90s, when competition lawyers felt really uneasy about defining relevant markets, because it's not what lawyers do. Lawyers by training, they apply tax law and property law, and they look up the property code that says how many months' notice to quit do you have to give a tenant. And now here you are as a competition lawyer, and you're being asked to define markets. And the competition lawyers say, well, it's all terribly difficult, it's all terribly uncertain, and it's not really fair to have legal rules that incorporate such a vague economic concept as market definition. Well, over the years, we've all learned how to do it. So lawyers have become more familiar with economic concepts. But if you look at the modern literature, the modern industrial economics literature, what an awful lot of economists say is, one of the problems with competition law is that the lawyers are so obsessed with market definition. And really, market definition isn't the point. The point is market power. So it kind of all feels a bit unfair, which is that we were told to understand market definition. We then all taught ourselves market definition, and now we're being criticized that really it's not the point. The point is market power. And what I'm saying basically today is that I think market definition is useful, but of course it is not an end in itself. It is just a beginning. It's a way of beginning to answer the real issue, which is, does a firm or will a firm have market power? So market definition is okay as long as it is not given a predominant role. And I can remember once talking to a judge in the Court of Justice and discussing this very thing that, an awful lot of economists say to me that the problem is that you lawyers, you over-obsess on market definition, and you should really go straight to the heart of the problem. Does Google have market power? And that judge said to me, yes, but Richard, I'm a judge in a court. My job in a court of law is to review the decision of the European Commission. It's a judicial review. We have to decide whether there was evidence that sufficiently supported the Commission's decision? Was there any manifest error of assessment on the part of the Commission? And these are very complicated cases. You know, Microsoft and Intel and Samsung and Motorola, these are difficult cases. If I'm a judge in a court, I need to have some way of understanding the process of reasoning, the ratiocination of the Commission. And for us as judges in courts, if you've got a decision that says relevant market, market shares, other relevant issues, barriers to entry, buyer power, if you're a court conducting a judicial review, it's rather easier to conduct a judicial review to check the quality of the authority's decision if it is divided up in this logical kind of way. If, on the other hand, I'm the court exercising judicial review and the decision just says X is dominant, how do you begin to judicially review that? So it seems to me this is one of these areas where legal process and legal rules can lead to better decision making, but on condition that we don't overemphasize the result of the market definition, and I'll explain that further in due course. So there we are. That's why we do define markets in the way that we do. It is actually a legal requirement. The authorities are obliged to do it, and of course this involves defining both the relevant product market and the relevant geographical market. But actually, for today's purposes, that slide is the single most important slide of what I want to say in this bit. Market definition is not an end in itself. It is a means to an end, because ultimately the really important question is, does a firm or will a firm post-merger have market power? And the market definition just enables us to attack the ultimate question, will there be market power? When I'm teaching my students, I always say it's a bit like trying to climb Mount Everest. If you're trying to climb Mount Everest, the first thing you do is go up to the base camp. At a certain altitude, you establish the base camp, and then you kind of conserve your resources and plan the next week's work. And of course, the week's work is to get to the summit up there. And I think market definition is just like that. We've got inevitably a complicated set of facts, we've got lots of evidence, we've got lots of competing arguments as to whether X is dominant or not. So we start by saying, well, what's the relevant market in relation to which X is alleged to be dominant? That's base camp 1. Now let's go on and come to the really important conclusion, does X have significant market power over that relevant market as defined? But what we mustn't do is to think that having defined the market, we've got an answer. We have emphatically not got an answer simply on the basis of the market definition. And as all of you know who've ever done this in practice, market definition is not a sort of an objective fact. People can disagree violently as to how broad or how narrow the market is. I mean, you think of somebody like Coca-Cola. What relevant markets do Coca-Cola operate on? Is there a market for cola-flavored carbonated soft drinks, or for carbonated soft drinks, or for soft drinks, or for soft drinks and alcoholic drinks? How narrow or how broad is the market? And frankly, reasonable people can disagree as to whether it's that narrow or that big. Now, I'm not too worried about the possibility of getting the market definition incorrect, provided that, having defined the relevant market, you acknowledge that there can be competitive constraints from outside that market as well as from inside that market. But I do think there's a danger, especially for some lawyers who perhaps want to find quick and easy solutions to problems, and who perhaps want to give legal advice to clients and who want to be sure that they aren't going to be sued for professional negligence. There can be a temptation to overly rely on the market definition and the market shares in order to reach safe answers. But in principle, of course, that is actually incorrect. So, another way of saying the same thing is, having defined the relevant market, of course we look to conditions within the market, which is another way of saying we look at market shares. I've got 58, you've got 22, somebody else has got whatever. But we must also look at the situation outside the market. So we've defined our market like this, but are there people outside that market who could enter it? Sometimes the answer is no, because the barriers to entry are very high. Well, if the barriers to entry are very high, then obviously the market share does tell us a great deal. Equally, however, if the barriers to entry are low, I might have 70% of a market, but there are people waiting in the wings to enter. There's nothing to prevent their entry. Well, in that case, I may not be dominant after all. So you must always look outside the market as well as inside the market. And you also have to look at buyer power, because in some circumstances, yes, I might have 65% of a market and somebody else has 35%, but I might be dealing with a really powerful and smart buyer who is perfectly capable of trading one supplier off against the other by threatening to cease to source from the supplier. So there are some cases, I'll give an example in due course, where buyer power can overcome a preliminary finding of dominance. So to put it another way, market share figures can never in themselves determine the question of market power. If anyone thinks that they can say 58 equals dominant, then they're making a mistake. There's always more analysis that must be done. And in particular, a firm with more than 50% of the market may be found not to be dominant. There was an interesting judgment in the General Court just before Christmas of last year. And this was in a merger case when Microsoft acquired Skype. So we all know what Skype is, and Microsoft years back had its instant messaging service. And so you've got Microsoft with instant messaging now acquiring Skype. And so was this going to make it dominant in however you want to define that market? Instantaneous communication, whether through video or just through text, etc. And depending on how you define the market, Microsoft was going to have a market share of 75% plus, so way, way above the AXO presumption of dominance, which is at 50%. And so, 75% of the market, or maybe more, that looks like a case for prohibition. And the Commission said, no, we're not going to prohibit this merger. We accept that there's a very high market share, but this is an IT market. It's a market that is changing incredibly quickly, and it might be true to say that on the 4th of February 2012, you've got a market share of 75%. But this market is changing so quickly that we think it is an open, competitive market. Barriers to entry are low, so we are unconcerned with a market share of 75% because the chances are tomorrow it might be gone, that position. And so the Commission cleared the merger. And Cisco, who of course has instant messaging type technology of its own, appealed to the General Court arguing that the Commission should not have cleared the merger, because with a market share as high as that, it's an obvious case of dominance, it should have been prohibited. And it's a very interesting judgment where it seems to me the court goes out of its way to say, you know, lawyers, especially courts, get accused of not understanding the underlying economics and looking for simple solutions based on market share. Well, in a case like this, we don't think the market share really tells us very much, because this is a rapidly evolving IT market. And the chances are that in no time at all, the technology will have moved on and people will be instantly messaging in some different way. So we get it. Market share is not everything. And of course, actually, we as consumers can see the truth of this. Who any longer uses Microsoft Instant Messaging? I think it's probably ancient history, isn't it? Because everything today is WhatsApp and Facebook. Oh yes, and Facebook are acquiring WhatsApp. Let's leave that to one side for a moment. But it seems to me that in this case, yes, very high market shares, and yet actually the Commission and the court say we're not worried. To me, this is a very good outcome. And there have been other cases like it over the years. Years ago, with pay TV in Italy, News Corp and Telepiù was actually, depending on the market definition, a merger to monopoly, depending on how you define the market. And yet the Commission allowed the merger subject to certain conditions. And some of you in the room will have worked in the mobile telephony sector, where I'm a mobile operator, you're a mobile operator. My customers sometimes phone a subscriber to your network, and so it's inevitable that the call has to terminate on your network. Well, how do you define the relevant market in those circumstances? It's difficult to see that the relevant market is anything other than call termination on the Vodafone network, because the call has to terminate on the Vodafone network. So competition authorities regularly come to the conclusion, a little bit reluctantly, that they are going to have to define a Vodafone call termination market. Now let's ask a difficult question. What market share does Vodafone have in the market for call termination on the Vodafone net? 100%. But does that mean it's dominant? Not really. So that's an example of a case where the logic of market definition leads you to this conclusion, and then if you slavishly proceed on the basis of market share alone, you're bound to say they're dominant, but actually it's just not right. So that's the central point then. Market share is not everything, and I believe you have a Supreme Court decision recently which actually reaches exactly that conclusion, but maybe somebody might like to say something about that in due course. Now, I don't think I'll bother with this next bit, because it's all about how you define relevant markets. The slides are there, it's all about substitutability and so on and so forth, and I'm assuming that people are comfortable with that. I will just make the point, of course, that you can have incredibly narrow market definitions in some cases, and you can have very, very wide market definitions in others. We had a case in the United Kingdom about, 10 years ago in the pharmaceutical sector, where there was a drug, a pharmaceutical product, that was used for the treatment of patients who have a neurological disorder called Gaucher's disease. And in the United Kingdom, I think there were 132 people in a population of 60 million who were suffering from Gaucher's disease. And a pharmaceutical company, Genzyme, had a drug that was able to deal with the problems associated with Gaucher's disease, and it was then accused of a margin squeeze. I won't explain the downstream market. But it was accused of a margin squeeze, and the Office of Fair Trading said the relevant market is drugs for the treatment of Gaucher's disease. So have you ever come across a narrower relevant market than that. But it must be correct, mustn't it? Because if you're looking at demand-side substitutability, if you can't get your drug for treating Gaucher's disease, you don't say, well, I'll take a paracetamol instead, or I'll buy some Lemsip, or I'll apply some suntan lotion to my skin, all of which might be very important things to do in other circumstances. The relevant market is this narrow market for Gaucher disease drugs. Equally, of course, you can have markets where the geographical market might be the entire world. I mean, that's just a fact of life. It is an empirical question. Now, I won't bother to go through the SNP test because I'm sure you are comfortable with that. Just to make the point about the 1997 notice, why did we ever have the notice on market definition? And I think it's an interesting point that we didn't have a merger regulation until 1989. So through the 70s and the 80s, the Commission would do maybe 2, possibly 3 abuse of dominance cases a year. And you'll know, especially if you've studied competition law, you get judgments like United Brands is the banana in a different market from an apple and an orange. And the Commission says the market is bananas. And there is a bit of a sense when you read the decision that the Commission thought, yeah, it's probably bananas, so it's bananas. There's not much empirical data to support that. So you sort of put your finger in the air, bananas, that's it. But then you get the merger regulation, and by 94, 95 or so, you're getting 300 to 400 merger notifications a year. And then in one merger, as you well know, there could be 40, 50, 60, 70, 80 relevant markets. And so you're now in a world where the Commission is having to define the relevant market in hundreds and hundreds and hundreds and hundreds of cases a year, with enormous consequences in terms of allowing the merger or not. And the United States adopted its merger guidelines in '92, which included the SNP test, and the sense then was that there had to be some objective, scientific way of thinking about market definition in Europe. And so that's how we ended up with the 1997 notice. It's an import from the United States, and it's a way of conceptualizing and introducing common methodology for market definition. And one of the things I find interesting going around the world is that wherever you go now in the world, the SNP test is the test of market definition. It's a universal product, which is in force absolutely everywhere. Now, I say that market definition is not an end in itself, and that's my mantra for today's purposes. However, one has to acknowledge that there's a certain kind of case in which the definition of the market actually has a crucial outcome on the answer. And it's only in certain kinds of cases, but sometimes you get a case where the market definition effectively is everything. And there was a prohibition of this merger a couple of years ago, Deutsche Börse and New York Stock Exchange, where these two exchanges were merging and they sold lots of derivative products. And a question arose as to whether derivatives that are traded on an exchange, are they in the same relevant market as derivative products which are sold, so say, across the counter, where they are individually negotiated rather than being a commodity-like product. And of course the exchanges said over-the-counter derivative products are part of a broader market. And basically when you read that decision is about the market definition. Because once you've reached the conclusion that it is derivatives sold on exchanges, it was a merger to monopoly. And in a case like that, there's no remedy that can remedy that kind of problem. It's going to be an almost pure monopoly. So we mustn't overemphasize market definition, but that's not inconsistent with acknowledging that in some cases the market definition might effectively lead to a conclusion. Another case in this region was Volvo and Scania years ago, where Volvo and Scania produced buses and trucks, and they proposed to merge. And the question in that case was, what was the geographical market? Was it the whole of Europe, or was it Sweden and Finland and Denmark and the United Kingdom? And the European Commission's conclusion was that each member state in itself was a relevant market, and in some of those relevant markets, Volvo Scania would be near to monopoly. So in some cases, market definition is hugely important, but that doesn't detract from the general point that I'm making. Of course, having defined a market, we can then look for market shares, and we have these various rules, over 50% you're presumed dominant, de minimis in certain circumstances if you're below 10 or 15%, vertical agreements okay if you're below 30%, but those are all presumptions, and because they're presumptions, it means they can be rebutted, and that's the crucial point. But you must always go on and look furthermore at the barriers to entry and whether there is any buyer power. Barriers to entry, very, very important. Are there tariffs that prevent products being traded into the EU? Is there a quota allocation possibly imposed by a member state which actually restricts somebody from increasing its market share? Are there intellectual property rights that prevent people from entering the market? Is it a market typified by economies of scale and economies of scope? Are there essential facilities upstream which you control? Network effects. I'm sure the reason that Microsoft was found to be dominant in the great Microsoft case was the network effect, whereby everyone tipped towards the Windows standard. Reputational effects, Ryanair. When the Ryanair-Aer Lingus merger was prohibited, part of it was that one of the barriers to entry, one of the things preventing airlines entering the market for flights into and out of Ireland was the fearsome reputation that Ryanair had acquired for ruthlessly eliminating any would-be entrant into the market. So your past behavior in itself becomes part of the barrier to entry, the reputational effect that you have acquired. So these are very, very important and always have to be taken into account, as lastly does buyer power, because in some circumstances, even though I've got a very high market share, I'm dealing with a very powerful customer who is able to trade me off against other suppliers in the market. So it doesn't happen very often, but there have been cases where a high market share in the end has been found not to indicate dominance because of the power of the would-be purchaser. So there we are. Those are the things I wanted to say about market power. But before I go on to the next bit, which will be relatively brief, object restrictions, does anyone have any questions or comments on what I've said so far? No? Okay. It was really an opportunity to give you a moment to relax and... oh, yes, please, yeah. Well, okay, first of all, let's distinguish substantive law from procedural law. But are you suggesting that even when it comes to substantive standards, there's a reluctance to follow? Yeah, a little bit better, but not perfect. Because I'd say a couple of different things about that. Firstly, if an authority or a court is applying 101 and 102, then clearly as a matter of primacy of EU law, one must apply the jurisprudence of the Court of Justice. That seems to me to be absolutely clear. And just on that point, thinking of Singapore, there was a case in the Singaporean Competition Appeal Board 2 years ago where the Competition Commission of Singapore had, what shall I say, taken notice of EU jurisprudence, and then an appellant criticizes the CCS for relying on EU law, and the appeal board in Singapore says, what's wrong with that? You know, if there's 50 years of jurisprudence and it all makes sense and clever people have thought deep and long and hard about this, why shouldn't we take advantage? We may not be formally legally bound, but you know, the expression in English, why reinvent the wheel? If over 50 years courts have said this is what is meant by a concerted practice, do you then say to the courts in Singapore, work out what a concerted practice is for yourself? This doesn't seem to be very efficient, and we believe in efficiency, don't we? So if the Singaporean appeal board is following EU jurisprudence, it seems, you know, a much stronger case that courts in Latvia or wherever else should do the same. Different point, of course, is what if it is a purely domestic case? That is to say, a case where there is no effect on trade between member states. And this is one of the things I was asked to talk about. I haven't done slides on it, but it's come up now. That's an interesting one. Suppose you have a case where there is no effect on trade between member states. Should the authority in the court in those circumstances interpret the same words in the domestic statute consistently with the words, with the jurisprudence of the EU? Now, I don't know technically what the position is in Latvia, but in the United Kingdom, Section 60 of our Competition Act, which creates a domestic prohibition for cartels and abuse, Section 60 of our Act says when the authority and the court in the UK is applying domestic law, it has a duty to maintain consistency with the jurisprudence of the EU. Now that's quite an interesting provision, isn't it? So this is not saying you have to apply EU law because you're applying EU law. This is saying when you're applying domestic law, even if EU law does not apply, you must interpret the domestic law consistently with the EU law. Now, to my mind, this is intelligent stuff, because I think we want to have a level playing field, and I personally don't like the idea that you could end up in a situation where the words of Article 101 mean one thing if there is an effect on trade between member states, but somehow have a different meaning if you're applying the domestic analogue of 101 but not 101 itself. So those are two different thoughts on substantive law. Procedure, now we have a problem. Because the procedural framework, the constitutional framework, can be so different from one country to another. I mean, some countries have the administrative system, other countries have the prosecutorial system. You have a system where the executive does the work and then the council makes the decision. So across 28 member states, you've got profoundly different enforcement systems. And I think in that situation, it becomes quite difficult to have harmonized procedures. Having said that, I can see the attraction of having harmonized procedures, because if 28 national competition authorities are applying 101 and 102, it is a little bit odd to think that the outcome could be very different in one country from another country because of the different procedural regime. So query, is there an argument for some procedural harmonization? Well, I would have thought the answer to that is yes. I think there is an argument for it. And I see that Andreas Mundt, the chair of the Bundeskartellamt in Germany, recently has been saying precisely this, that we need more procedural harmonization. And there was a judgment of the Court of Justice last year, in June of last year, which was the Austrian Competition Authority against Schenker, where it seems to me the Court of Justice in that case has started to superimpose procedural convergence on member states, saying, for example, that if a national competition authority finds a violation of 101 or 102, it must impose a fine. That's an interesting statement, because national law might give the authority total discretion as to whether to impose a fine, and then the Court of Justice says if you find an infringement of 101 or 102, then in order to safeguard the effet utile of competition law, the national authority must impose a fine. Well, that looks to me like the beginning of imposing procedural convergence. What's your thought on this? Would you like there to be more procedural convergence? I have market power if I'm able to increase my prices over a period of time. I don't think that has reference to the concept of abuse of dominance. I mean, obviously the point is I might drop my prices in order to eliminate the competitor. But having eliminated the competitor, the supposition has to be that I can then put my prices up to the profitable level. So, I mean, the definition of market power can't include the power to reduce prices. Anybody and everybody can reduce prices, so I wouldn't factor that into the definition of market power. Okay? Any other questions at all? Okay, well, look, let me go on to the other thing I was going to talk about this morning, and it's this interesting question of object restrictions. So what I've been saying is that it all depends on market power. An agreement can only have the effect of restricting competition in a market. I can only abuse a dominant position, meaning I've got significant market power. But then Article 101 talks about agreements that have as their object or effect the restriction of competition. And an awful lot of the controversy today is around this question of what do we mean by an agreement that has the object of restricting competition. And if you do have an agreement that has the object of restricting competition, does the authority or the court still have to demonstrate effects? Do you have to show that the object restriction will lead to higher prices? Or is it sufficient to say it is an object restriction? This is certainly one of the areas where the lawyers and the economists become particularly irritated with one another, because you have a case last year, the bananas case in the General Court, where 3 banana producers have been exchanging information with one another. And the Commission says this exchange of information has the object of restricting competition. And the banana producers, through their economists, say, but we can demonstrate empirically that the exchange of information did not lead to higher prices. So we can show that this exchange of information had no effect on the market. That's what we as economists can do. But then your stupid law says that because it's an object restriction, therefore it follows that the exchange of information is illegal, even though we can prove that it produced no effects. So one economic consultancy put out a briefing paper in which it described this as the catch-22 situation. You know, the catch-22 situation is that I'm a pilot at a time of war, and I have to take my airplane into enemy territory, and it's an enormous risk to myself, and I might be shot down and killed. And the only ground on which I can refuse to fly the aeroplane is if I'm insane. So I go to my powers that be and claim insanity. And the answer is, if you're clever enough to run the insanity argument, it must mean you're not insane, so get in the plane. That's the catch-22 situation. And then here the economists say, we can prove that this agreement had no effect. It's just that we're not allowed to, because the law says it's an object restriction. So this is the catch-22 situation. So obviously this is controversial stuff. And today's talk is about market power. Well, do you have to have any kind of effects analysis in an object-type case? And many of you will have seen the Court of Justice's judgment in Expedia in 2012, where the French authority, the French competition authority, says it's come across an agreement and it contains an object restriction. And then you get an appeal that goes up through the French appellate structure, and it ends up in the Court of Justice in Luxembourg. And many of you will remember from 1969 a judgment of the Court of Justice called Volk and Verwerke that said for an agreement to violate Article 101, firstly, you must show that it has an appreciable effect on trade between member states. And secondly, you must show that it has an appreciable effect on competition. So there's a double test of appreciability, because obviously conceptually, the question of whether there's an effect on trade is a different conceptual question from whether there's an effect on competition. So Volk and Verwerke requires double appreciability. And then in this Expedia judgment, the Court of Justice says, let's assume this is an object restriction. I don't think that case was an object restriction, but we have to assume it for the purposes of understanding the judgment. The Court of Justice says, if that is an object restriction, then you've got a prior question. Does it appreciably affect interstate trade? But then the court says explicitly, I think it's paragraph 31, if the agreement has an appreciable effect on trade between member states, then any object restriction automatically has an appreciable effect on competition, and there is no need to demonstrate that fact on the basis of evidence. So Volk and Verwerke required double appreciability, but Expedia says if you've got interstate trade appreciability, you don't have to go any further. It's just illegal, period, just like that. And so, of course, the Commission has now rewritten the de minimis notice, and any time now the revised notice will be published, and it will incorporate the Expedia jurisprudence. It seems to me that that clearly changes the law, because historically there had to be double appreciability, there no longer does. So that's an interesting one. So do you have to define the market and determine market power in these cases? Well, actually, there's a more recent judgment of the Court of Justice, Ziegler against the Commission, and that deals with the International Removal Services cartel. And what happened in that case, there was bid rigging for contracts to ship in and ship out household contents into and out of Brussels. So the interested parties here were the Commission officials going on secondment to Brussels and then back to their member states. And the Commission said this is an object restriction, and they did not define the relevant market. And Ziegler appealed to the General Court and said the Commission should have defined the relevant market. And the Commission said, no, that's not true, because this is an object restriction. And if it's an object restriction, we don't have to define the relevant market. And the General Court said, actually, Commission, you're wrong there. You do have to define the relevant market. Not for the purposes of discussing whether it's a restriction of competition, but because of the requirement to show an appreciable effect on trade between member states. And specifically what the court says is, you, Commission, have published a notice on the concept of trade, an effect on trade between member states. And that notice contains a safe harbour whereby firms can say they do not have an appreciable effect on trade between member states because their market share is below 5%. And so what the court says is, if you, the Commission, have published a notice on effect on trade that contains a safe harbour based on market share, it follows that you do have to define the relevant market. Because without defining the relevant market, how can you, the Commission, be satisfied that Ziegler is not below the market share? So that's a bit curious, isn't it? That we've now got to the position where you don't have to define the market in an object case for the purpose of determining whether there's an appreciable restriction of competition, but you do have to define the market in order to satisfy yourself that there is not an appreciable, because it's a safe harbour. What the court then did in Ziegler, the general court, the judgment I recite here is the Court of Justice, but what the general court said is, the Commission must define the relevant market for the purposes of appreciable effect on trade between member states. Now, admittedly, if you read the Commission decision as it is written, there is no point in the decision, as there would be in an abuse of dominance case, where the Commission says relevant market and then define the relevant market. In the International Removal Services case, the Commission had never done that because in its view it was not necessary to define the relevant market. But what the General Court said was, however, if we read this decision, and we've got the case file in front of us, it's pretty obvious, no, not pretty obvious, it is obvious that the Commission did define the relevant market as international removal services. It just doesn't happen to have a section in the decision specifically spelling this out. But it is obvious that the Commission did think within a market definition, and furthermore, looking at the facts of the case, it is absolutely obvious that Ziegler's market share is way, way, way above 5%. So actually, there is a requirement to define the market, but we think there's enough in the decision for us to understand what the market definition was and to let the Commission off. And then Ziegler appealed on to the Court of Justice, saying to the Court of Justice, we believe that the General Court has committed an error of law because it's basically given the Commission a free pass. It has effectively exempted the Commission from market definition. And the Court of Justice says, no, we think that's unfair to the General Court. They did go into the facts of the case. They were satisfied that there was an appropriate market definition, and therefore we uphold the Commission decision. So it seems to me, the way I've expressed this is, there does have to be some market definition, but it seems to me it's pretty light touch market definition. This is simply for the purposes of satisfying a jurisdictional threshold, simply for the purposes of establishing that Ziegler was not below 5% of the relevant market. So I don't think this kind of market definition is the market definition that you have to do, in an abuse of dominance case or whatever. A different point is, what if it was a purely domestic case? Going back to your question, this is rather fascinating. Suppose you have a situation where the Commission or the authority or the court is applying Latvian law or Lithuanian law where there is no effect on trade between member states. How does Expedia work then? Because what Expedia says is there is an appreciable restriction of competition if there's an appreciable effect on trade. But if you're dealing with a purely domestic case, ex hypothesi there is no effect on trade between member states, because if there is an effect on trade between member states, you're applying Article 101. So if you're not applying Article 101, do you reach the conclusion that any object restriction is appreciable, or do you have some quantitative requirement in that situation as well? That's rather intriguing, but I believe you've had a case on that in Latvia already. Anyway, it's obvious if it's an object restriction, there's no need to prove effects. We all know that from STM, repeated probably 50 times since then. Economists don't like this because they think you should always look for effects, and this object characterization seems rather formalistic and so on. Of course, even in an object case, effects do matter, because the authority, having said there's an object restriction, firstly, then has to decide what the fine should be, and I think it's inevitable that the amount of the fine is likely, at least in part, to reflect how serious the impact of the agreement was. So effects can be relevant to the fining position. And secondly, where there's an object restriction, anyone who has had to pay higher prices as a result of the cartel can bring an action for damages in a national court. Well, obviously, if that's the question, can I recover damages, that is purely an effects question. But this is tort law or delict law. Did that infringement of the law cause me harm? And if it caused me harm, how much harm did it cause me? So that's a quantum question. So we're not saying that object restrictions are completely separated from effects analysis, but the effects analysis is for the purposes of fining and damages awards rather than for the purpose of establishing liability. A separate point about object agreements, and I mean, I could give a long talk on this, and indeed I did at the Norwegian Competition Authority on Tuesday. Really intriguing legal question. If you have an agreement that restricts competition by object, can it be defended under Article 101.3? Or, if you say it's an object restriction, is that a per se infringement of competition law? Now, I find this one of the most intriguing bits of all of Article 101 jurisprudence at the moment. In my head, I'm absolutely clear that what the law says is that even object restrictions can be defended under Article 101.3 as a proposition of law. And the Court of First Instance, as it was, the General Court now, in Matra Hachette and the Commission about 20 years ago, it's paragraph 85, I actually read it out in Bergen on Tuesday, says explicitly that there is no type of agreement that cannot satisfy 101.3, provided that the four conditions of 101.3 are satisfied. Now, if you've got a secret cement cartel that's been in operation for the last 15 years, where people have been going secretly to Zurich to have cartel meetings and giving themselves code names, you know, Groucho Marx, Harpo Marx, whatever, meeting secretly, deciding not to produce anything in writing, blah, 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 it seems to me incredibly unlikely that that kind of object restriction could ever satisfy the conditions of 101.3. It's just a basic, simple, straightforward, secret conspiracy against consumers. But you could have something totally different, which analytically might amount to an object restriction, which nevertheless might satisfy 101.3. Last year, the Commission accepted commitments and therefore permitted the Star Alliance system in air transport, where Lufthansa and I think was it United or Delta basically merge their routes to create a better hub and spoke system for transatlantic travel. Now, if those two airlines agree to stop competing with one another, to share revenue, to share codes, etc., to my mind, that is a restriction of competition by object. And I am told that the Commission regarded it as a restriction of competition by object, but nevertheless it allowed the alliance to go ahead because the Commission says in its press release, this alliance leads to efficiencies. It leads to stronger hubs at Frankfurt and at JFK in New York, and consumers who are trying to fly, say, from Bratislava to St. Paul's, Minneapolis, now have the benefit of a stronger merged entity with better hubs and spokes going to further places. Well, actually, to my mind, this is a 1013 defense to an object restriction. So it's rather like my point earlier about market definition. It helps us to reach a stage in the investigation, but there's more that has to be done. This business of object restriction, it wouldn't matter to say that something is an object restriction as long as people have the confidence to believe that even in the case of an object restriction, they can still argue a defense under 1013. But what I find is, when I talk to practitioners and when I talk to some Commission officials, there seems to be a deep-seated belief that if you've got an object restriction, that's the end of the matter, and the agreement is per se illegal. And it seems to me that this is profoundly wrong and very, very unfortunate in practice, because it's almost as though we've got hold of Article 101, cut it in half, and thrown half of it away. Why would we do such a thing? So I think there's something profoundly unsatisfactory here, and maybe people would be less worried about object analysis if there was a recognition that even object agreements can, depending on the evidence, satisfy 1013. Now, as far as object restrictions are concerned, as I keep on saying, there are lots of people who don't like the idea of object restrictions. Does industrial economics tell us that there can never be an object restriction? Well, I don't think it does, actually. This is about legal process, legal presumptions, burden of proof, who has to prove what. Industrial economists would agree that if you've really got a price-fixing cartel, it is highly unlikely that a price-fixing cartel is going to be to the benefit of consumers. It is overwhelmingly likely that it is harmful to consumers. And so it seems to me that to say that something is an object restriction is in itself a version of effects analysis. Because what one is saying is, it is so likely that this agreement will have effects that you don't have to prove effects. And I do think that there's quite a lot of sense to that, provided that one recognizes that this is simply a legal presumption. And so then it becomes a question of, well, to what agreements does the legal presumption apply? I've always used this language of the object box. Which agreements do you put into the object box? And to my mind, you put agreements in the object box if they are, what word shall I use, highly likely to have an adverse effect. And so it's not unreasonable, is it, to suggest that horizontal price fixing is likely to have an adverse effect? So we put it in the object box. Horizontal division of markets, quotas, these are the classic cartel behaviors. Collusive tendering, I believe you've had one or two cases of collusive tendering in Latvia, and it's all over the world. It's a rampant practice, and to me it's just utterly offensive behavior. Of course it is highly likely to have an adverse effect on consumers. EU law is very obsessed with the single market, and that's why there's always been such a strong line taken on export bans. We are meant to think in terms of a 28 member state market. Resale price maintenance in vertical agreements, there's an interesting one. I believe you may have had a resale price maintenance case in Latvia. Now, the law regards RPM as an object restriction. Lots of economists don't like that because they say that RPM may have pro-efficiency justifications. I have to say, to my mind, this is precisely when my point about 101.1 and 101.3 kicks in, because I can see sense in a rule that says RPM is an object restriction, because it seems to me it is highly likely to have an adverse effect. However, I also entirely recognize that economic theory suggests you could have a particular product where the risks of distribution are great, where the sunk costs of entering the market are high, that without some protection from intra-brand competition, distributors may be unwilling to enter the market. Well, to my mind, this is precisely what 101.3 is designed to achieve, because the object analysis presumes that this could have anti-competitive effects. But then what does 101.3 say? It says the prohibition in 101.1 may be declared inapplicable in relation to an agreement that leads to an improvement in the production or distribution of goods from which consumers get a fair share of the benefit. To my mind, 101.3 is written precisely with a situation like RPM in mind. Maybe there is presumptively a restriction of competition, but there might be economic justifications, but this is a 101.3 argument, and of course the point being that with 101.3, the burden of proof flips to the supplier and distributors in question. Prove that your product justifies RPM. You have the evidence, you know the market case, bring the evidence and persuade us. So again, we're in the world of legal presumptions. If I've got more than 50% of the market, I'm presumed to be dominant, but I can argue that I'm not. I'm involved in RPM, it's an object restriction, but let me now have my opportunity to argue that there's an economic justification. And what I think has gone completely wrong in this area is the perception that if it's an object restriction, you've got no further right to argue your case. As I see the jurisprudence and the way that the treaty is itself written, it's perfectly clear that you should be able to bring your efficiency arguments to the table. I think that there is sound reason for object analysis. Firstly, if you're trying to do compliance training for the people that work in firms, I think it's quite useful to have some bright line rules whereby as part of a training program you say there are some things that you really should not do. And actually, you know, price fixing is one of them and collusive tendering is another. So having some bright line rules is, I think, useful in terms of getting the message out, provided that in any case, if you've got a reasonable argument to justify the behavior in question, you can still invoke Article 101.3. And I think there is this very important point that competition authorities do have limited resources. And trying to prove the existence of a cartel is not easy, because you've done your dawn raid, you've done your requests for information, and then you end up with the most monumental amount of material, and you've now got to piece it all together to work out whether there was a widget dioxide cartel or not. This is difficult stuff to do. I think if you were to say, okay, authority, you've now proved the existence of the widget dioxide cartel, now prove that that led to higher prices, I think you can get to a point where it becomes almost impossible for the authority ever to secure a conviction. So we are in this world of false positives and false negatives here. So I think there is a clear policy justification for object analysis. And of course, this is discussed very cogently by Advocate General Cocotte in her opinion in T-Mobile, where she makes those two particular points. A, teaching what the law is, and B, conserving the resources of authorities. So that's fine, but there is a lot of concern in this area. And the concern comes about because the Court of Justice, in some judgments, seems to be willing to expand the size of the object box. The object box, rather than getting smaller, seems to be capable of getting bigger. And I don't know how many people have read this judgment of the Court of Justice last year, Allianz Hungaria. I won't even begin to try to explain the facts now after you sitting here for 2 hours listening to me. It's horribly complicated. But suffice it to say, I think it's the most appallingly terrible judgment in which the Court of Justice ends up deciding that vertical agreements between insurance companies and car repairers and brokers were restrictive of competition by object in circumstances where the vertical agreements did not contain export bans, nor did they contain resale price maintenance provisions, and yet the court says that the restrictions in that agreement, those agreements, were restrictive by object. And I cannot for the life of me understand how the court reached that conclusion. And every time I read the judgment, I get more frustrated than the previous time, because it just doesn't seem to me to make any sense. And at one point, the court seems to say, well, with this object restriction stuff, what you have to do is to look at the market, and then you have to look at the effects that the agreements are having in the market, and you look at the market shares of the parties, and if at the end of all of that you think that there's highly likely to be anti-competitive effects, then it's an object restriction. Well, what does that mean? That seems to me to be a complete and absolute nonsense, because if you have to do effects analysis to reach the conclusion that it's an object restriction, I don't see what this has achieved, and it certainly hasn't benefited the authority which is trying to conserve resources. So I think this judgment is, frankly, terrible. It confuses the picture, and for people like me that are happy to justify the existence of object restrictions, I can only justify the existence of object restrictions if the category of object restrictions is significantly limited to cases where there is an obvious restriction of competition. Horizontal price fixing, obvious restriction of competition. Market sharing, obvious restriction of competition. Therefore, you don't have to do effects analysis. But if you've got something like Allianz Hungaria, where the facts are astonishingly difficult, and even having read the judgment 4 or 5 times, it's still not entirely clear what's going on. If it's that difficult, how can it be an obvious restriction? And if it's not an obvious restriction, then it just should not be in the object box. So I think the Court of Justice in that judgment has done a great disservice to everybody involved in this business. I just think it makes things mysterious that should not be mysterious. And my last comment, therefore, is to say, watch out for a forthcoming judgment of the Court of Justice, carte bancaire, against the Commission. This is about a French payment card system where the incumbent banks who set up the CB system charge fees to participants in the system, and new entrants to the card system have to pay higher fees than the incumbents who set up the system in the first place. And the Commission said that's a restriction by object. And CB appealed to the General Court, and the General Court said that's a restriction by object. And now CB have appealed to the Court of Justice, and earlier this year, Advocate General Wahl gave his opinion in which he says that's not an object restriction at all. This is not an obvious restriction of competition. Indeed, there may be very good reasons to explain why the new entrants who did not incur the cost of creating the system in the first place, there may be a perfectly good explanation for asking them to make a higher contribution now through the form of their fees than the people who originated the system in the first place. So this is a really interesting moment approaching. What will the Court of Justice say in the CB judgment? I'm not going to place any bets, but I will simply say it's going to be a very interesting judgment when it comes out. And so to conclude, competition law is all about the economic analysis of markets within a legal process. That's why economists have to respect the legal process, and lawyers have to understand that economists do insist on good analysis of markets and what's going on. You cannot be in this business without, as a lawyer, having some feel for the economic concepts, or as an economist, understanding the need for legal process and indeed legal rules, including presumptions. But as I've tried to demonstrate, ultimately, it really does all seem to come down to market power. That's the central concept unifying the whole of the subject. So thank you very much for your attention. Well, I mean, immediately Feneen comes to mind. And I think Feneen was absolutely fascinating because, I assume most of you know this case, but it's where you've got effectively the Spanish health service purchasing medical equipment from suppliers of medical equipment. And Feneen represents, it's the association representing the suppliers. And what was happening was the suppliers were selling their products to the Spanish Health Service, and basically the Spanish Health Service did not pay its invoices. So 3 months, I still haven't been paid. 6 months, I haven't been paid. 9 months, I still have not been paid. So there's a lot of mañanas involved in this situation. And of course it means effectively that the small suppliers in some cases are supplying credit to the Spanish Health Service, and it doesn't feel quite right, does it? And so Feneen made a complaint to the Commission saying that the Spanish Health Service is a monopsonist, it has buyer power, and it is abusing its dominant position through unfair trading conditions. And if you were simply to ask the question, are these unfair trading conditions? Well, it seems to me absolutely obvious that these are unfair trading conditions. And I think the Commission accepted that this was unfair practice and that the health service was in a dominant position. But then the Commission says, however, we do not believe that the health service is an undertaking. And the way that the reasoning goes is that an undertaking is somebody involved in economic activity. This is purchasing, but the purchasing is ancillary to the downstream service of providing health care to citizens in Spain. That is not an economic activity, so the procurement is ancillary to a non-economic activity. Therefore, the purchasing itself is not economic. So, and you know well, that's what the judgment says. Seems to me, if it had wanted to, the Court of Justice, Commission, and ultimately the Court of Justice could perfectly have decided that the other way. I think you could argue that purchasing is of its nature an economic activity. You have discretion, you're deciding whether to buy from them or them or them. This is economic behaviour. But I imagine that the Commission and the Court and the General Court and the Court of Justice did not want effectively to impose non-discrimination rules, etc., on the health services and presumably the educational services and God knows how many other services of 28 member states across the EU. So I always had a feeling that there was a strongly political component to what the court decided. And of course, there are public procurement directives, so to some extent, didn't deal with this situation, but to some extent, procurement is dealt with through alternative legislation. So I think there was, one of these moments when the court says, what are the consequences of this, and will it be acceptable to member states if we subject all of their procurement to competition law? They ducked it, quite frankly. I don't know whether you're aware, but do you know we had a case on this in the United Kingdom called Better Care? Yeah. So it was quite amusing. At the same time that the Feneen case was going through the Brussels-Luxembourg system, we had a case in the United Kingdom where there was a health authority in Northern Ireland that was refusing to purchase certain services from services suppliers, and they complained to the Office of Fair Trading. And the Office of Fair Trading decided not to proceed with the case on the basis that the Health Trust was not an undertaking. Better Care appealed to the Competition Appeal Tribunal. At the time that the tribunal was dealing with the case, the judgment in Feneen had not been handed down. So therefore, our tribunal was not bound by any precedent in Luxembourg, and our tribunal basically said, we are not comfortable with the idea of just carving out governmental procurement from competition law. So the Competition Appeal Tribunal decided that the Health Trust was an undertaking, and then 6 months later, the General Court says that the Spanish Health Service was not an undertaking. So then you had a clear conflict between the two outcomes. So subsequently, the Office of Fair Trading looked at it again in the Better Care case. Should we now find an abuse of a dominant position? And what the Office of Fair Trading did was to decide that the behavior in question was not abusive. Therefore, it didn't need to decide whether the Health Trust was an undertaking. So it's one of those things that just gets nuanced out of existence, but it's obviously very sensitive stuff. And I do think that the court, if it had wanted to come to the opposite conclusion, I'm sure it could have done. Well, I suspected this issue might come up, and I know there are various countries that have this kind of law, and I think it's a very difficult area. I personally don't like the idea of competition authorities being given this special jurisdiction, because I think competition law and policy is difficult enough in itself. And one of the things I've been trying to argue here is that we've spent 50 years trying to get to a point where the three pillars are all in harmony with one another. And I think we have achieved a great deal, and we are worried about significant market power. And then, the Commission in the Enforcement Priorities Guidance says, we're not in the business of protecting competitors as such. We're in the business of protecting hypothetical as efficient competitors. And it all makes a lot of sense. And I think it becomes easier for everybody, the clients, the lawyers, the economists, the officials in the authority. I think it becomes much easier to have respect for a system if it is intellectually coherent and if it's all centered around the idea of significant market power. And then a government, for whatever reason, decides we don't like retailers with more than 30% of a market. And so here's an extra bit of law. Get on with it. Well, I just wonder, what is a competition authority supposed to do in those circumstances where it has tried to come up with a unifying set of principles based on the idea of market power, and then it is told arbitrarily that certain undertakings are subject to an additional form of control? Well, what is this additional form of control? Why is it there? Is it because these retailers are harming competition in a conventional sense? Well, if they're harming competition in a conventional sense, I would say you use conventional competition law to capture the offence, including, if necessary, collective dominance. But if you're saying these retailers worry us because they're being unfair to farmers, for example, I mean, we've had all this in the United Kingdom. If it's about some sort of unfair dealing, unfair contract terms or whatever, I've no doubt there might be unfair contract terms, but it just seems to me that that's a different kind of law and you use different principles to deal with it. And I can see how a government designing legislation and faced with angry farmers or angry food producers or whatever might feel that they've got to do something, they've got to give some protection. And then, of course, what governments do is to say, we're going to give the protection because that might mean we get re-elected after the next general election. Now we've got to find a public body to do this for us. Well, who should we give this to? There's the VAT tribunal, the immigration. No, I don't think it. There's the competition authority. Let's give it to them. And so you have this jurisdiction dumped upon you that very possibly you don't want, and which is going to be very difficult to apply in harmony with the rest of what you do. So, well, you can see what I feel about this. I'm not sympathetic to governments giving this role to competition authorities. Just over the water, you know, in Finland, this is precisely where they are at the moment. We had it in the UK, and the question was whether to refer supermarkets for an in-depth investigation. So you've got the suppliers up here, you've got the supermarkets here, and you've got us as consumers down here. And the Competition Commission said that, okay, you've got very tough terms being imposed on suppliers, but as long as you've got enough competition in the retail market, this will lead to lower prices to consumers. Well, the consumer welfare story is about lower prices to consumers. And as far as we can see, as technicians of competition policy, this market works well for consumers, except that there were some towns and cities in England where one supermarket chain had a local monopoly. Well, if they've got a local monopoly, then obviously competition isn't going to give consumers a fair share of the benefit in the downstream market. So you deal with that monopoly problem, but you don't deal with it by using a bespoke bit of law that arbitrarily says they're dominant. You actually do it through conventional competition analysis. And then if there's unfairness between farmers and the supermarkets, well, what we have done is to create a totally different code, and we have a groceries ombudsman. And a woman has been appointed as the groceries ombudsman, and she adjudicates on whether the terms of supply between the supplier and the supermarket, are they in some sense unfair? Well, that seems to me to be a perfectly reasonable thing to do, but it's a separate system, it's administered by different people, it will evolve its own case law and decisional practice and so on. I'm happy with that, but I don't want that to contaminate the economic analysis that the authority conducts. Well, sure, and I mean, frankly, I think that's, you remember my slide about dominance being a binary concept. This is where we get into this problem of false positives and false negatives. And I think at this stage, this is a kind of a philosophical point again. Let's face it, any competition authority in a particular case sometimes is going to reach the wrong conclusion, not because it's not a good competition authority, but because ultimately this is a matter of judgment and assessment. And sometimes the authority is going to go the wrong way, either by letting off bad behavior or by finding good behavior illegal. It is a fact of life. So we have to have judgment, and we have to have good judgment, and it seems to me that at the very least, the judgment has to be exercised against clear principles. Now, one of the things you can do is to decide as a matter of policy that we are not going to protect competitors for the sake of it. We're actually going to protect competitors that are as efficient as Domco. If Domco is just clearly better than its rivals and it's offering lower prices and they can't hang around in the market, they can't take the heat, well, bye-bye. On the other hand, if you've got an equivocal case and you're really not quite sure, is it this side or this side of the line, you're using that principle, which in itself helps you to exercise your judgment. But if at the end of the investigation you're still not quite sure, then surely, I don't know what your burden of proof is in Latvia, but we say that the competition authority has to be satisfied on the balance of probabilities that this is abusive behavior. So if you've investigated something for 2 years and you're applying the balance of probabilities standard, you are asking, is it more likely than not that this behavior is abusive using the as efficient competitor test? And if you've got a doubt, then the answer is you say not guilty. But in the end, it is a matter of assessment and judgment. So I think you've got to, in your head, you've got to be thinking, well, what are we trying to achieve here? What is the policy? And so on. I personally do not think one should use competition law to protect less efficient competitors. I can't see where the consumer welfare gain is of maintaining people in the market just for the sake of maintaining them in the market. I think that sends out very bad signals. Well, the first thing I would say is that it's absolutely clear to me that competition authorities must be entirely independent of ministers, the state. That is a complete sine qua non, because I think competition authorities should be technicians who basically look at market power, they ask if the market power is there, and then they reach decisions accordingly. And the idea that you've got a minister sitting on your shoulder overseeing what you're doing and trying to nudge you in this direction or that direction, it seems to me that is a complete abomination, to be perfectly honest, because I think you have to have independent authorities conducting technical analysis. I think that goes without saying. And I have to say that there are some not very encouraging signs around at the moment, including within Europe. I'm not going to name countries, but I can think of at least 2 at the moment where the independent authorities have recently come under a serious threat from governments. And that is something I had not expected to see. I think it's a terribly disappointing development, and so I think it's terribly important to go on bashing away at the need for independent authorities. Apart from anything, how can you have meaningful competition advocacy if you're not acting as an independent assessor of the competitive fabric of the market? I mean, the whole point of being an advocate is that, of course, states have a whole range of policies. And I would never say that competition policy trumps all other policies. There might be other policies that are more important. But what I do want to do is to have one authority in any member state that has the ability at least to put the competition arguments. Now, if in the end a minister or a government or a parliament decides to say, we understand the competition arguments, but actually we think these arguments are more important, I think governments have the right to do that. But I still think that the authority, when it is fulfilling its role, should be absolutely independent and not subject to any kind of influence, whether it's the threat of removing members or the threat of reducing next year's budget or whatever it might be. There are lots of subtle ways in which member states can undermine the independence of all authorities. So yes, I'm absolutely in favour of independence. The other point you mentioned is judicial review. Competition authorities do have significant powers. And of course, undertakings that are being accused of abusive behaviour and being fined large amounts of money, they're not going to be happy, and they're going to protest that they did nothing wrong, and so on and so forth. That's the way life is. But undertakings can believe in competition policy, and I think they should believe in competition policy. Undertakings themselves benefit from having fair markets where people don't abuse and cartelize. It's rather interesting to find nowadays that Michelin and Deutsche Bahn, who over the years have often been found to have infringed competition law, now have a policy of looking at any cartel decision to find out whether Michelin or Deutsche Bahn have been the victim of cartels. And they, well, this is all in the public domain, those two companies now have a policy of bringing follow-on actions for damages whenever a cartel has been discovered that has an effect on them in the marketplace. So if you're Michelin, rubber cartels, I've got a feeling that rubber is used to make tires. Freight forwarding, I have to purchase assets from around the world. There's a freight forwarding cartel, there's an air cargo cartel. And so there now you've got undertakings that are themselves using the competition rules to their advantage. So you can make undertakings see that competition law is good rather than bad. But I think that undertakings will only believe in the law and acknowledge that sometimes they might be caught out if they believe that there is an effective judicial review by a body sitting above the authority. So I think there does have to be effective judicial review, and I think ultimately that benefits the authority itself. It's a form of competition. I want to win, but I want to win cases on the merits, and if I do a good job of work and there's then an appeal to a court that robustly reviews my work and at the end says, tick, we agree, that's a pretty good position for the authority itself to be in. And of course, it means that the system is human rights compliant in terms of Menarini Diagnostics in Italy and two judgments in the Court of Justice, KME and Chalcor, against the Commission. So I think you do have to have effective judicial review, and I think at the end, everybody in the system, including the authority itself, benefits from good judicial review. But I don't mean judicial review where a judge in a court finds a procedural error and on the basis of that annuls a decision. I find that just utterly irritating. I think that the court that does the judicial review has to understand what's going on and try to get to the underlying merits of the case rather than proceed on the basis of mere procedure. Thank you very much.
I take this opportunity to congratulate you with the excellent speech. And for us, for Competition Council of Latvia, I think concluding remarks are very important because we are striving really to get full independence because we know what kind of work lies us ahead, and especially by assessing market power, assessing different competition restrictions, we are getting more and more transnational and global. And it's indeed a great honor for us to welcome you in Riga, to meet you in Riga, and I think today we will have very lively discussions afterwards. We have left time, and I think there will be many questions what we'll give to you and wait what you will answer us. And yes, I take this opportunity to thank you for your really excellent all work that you have done, prepared, what we are using every day in our work, for your speeches, articles, for your book, Competition Law, which is really like a textbook for us, for practitioners, what we use every day, what we have started our career with your book. And thank you very much for coming to Riga and for your all contribution. Thank you.
Thank you very much.
Thank you.